citizen, banking institutions are more dangerous to our liberties than standing armies. And yet, the banks argue that their job is primarily in the buying and selling of exchange and interests. Today on Law Express, we take on the topic the banker customer relationship within the context of the obligations owed by the bank to its customers. My name is Bella Seju. This is Law Express. Stay tuned.
Michael Tepatina is a private legal practitioner who enjoys watching football, reading books, and listening to music in his free time. George Oforia J is a dedicated private legal practitioner who enjoys spending his free time on various hobbies. You can find George swimming, reading a good novel, or hiking through scenic trails when he's not providing legal counsel.
Nuala Seidu. She's a private legal practitioner and a consistent member of our 3-lawyer panel on the show every week. She also doubles as the host of the show. She likes to play tennis and read.
So we are discussing the banker-customer relationship. I think it's important that we take note of the terms therein and then focus our discussions based on those terms. So first of all, I would like us to look at what is a bank. What is a bank? Because we are looking at the duties of a bank. So first of all, let's understand what a bank is. So generally, and in simple terms, a bank is an institution or financial institution licensed with a primary duty or function, if I may say, of accepting deposits and granting loans, which are the traditional functions of a bank. And it's important I emphasize the point on accepting deposit because we have financial institutions who perform other duties other than accepting deposits. Some financial institutions have been licensed only to grant microcredit. Those people don't have the mandate to accept deposits. And so a bank is one that has been licensed to accept deposits. And this definition came out strongly after the banking crisis, and it's in the new banking acts that we have. So that is what I will say about a bank. And then thereafter, I would like to touch on who a customer also is briefly, so that we'll get to know the relationship. So a customer has traditionally been defined as a person who has an account with a bank. That's the traditional definition from time immemorial. So, but as things have evolved, banking has also evolved. So the definition has now gone beyond merely somebody having an account. There are some definitions that expanded to a person that a bank provides financial services to. So it may not necessarily be somebody who has opened an account and runs an account with a bank, but it may be somebody that other financial services have been rendered to.
Then the next question that would automatically pop up will be, how does the banker-customer relationship start, and then how it evolves over time?
Okay. Normally, the relationship starts from the person opening an account with a bank.
Okay.
But with a modern advancement in technology and stuff, the person might not necessarily have to open an account before the person will be a customer. So the relationship starts from a whole lot of interactions that the bank may have with the person who would either walk in, who would either place a call to the bank, or who would either make an inquiry and would want to seek further clarity about services that the bank offers. So that is where the relationship starts.
But if essentially should have all the requirements of a valid contractual relationship, and it's usually based on good faith, mutual understanding between the parties. They should be of same or like minds in respect of the nature of the relationship that they are entering into.
You see, let me just make this point, and you've made a valid point. So that relationship between the bank and the customer is a contract.
Yes.
So all the elements of contract that we know must be present. For instance, the issue of capacity. You know, before somebody can open an account in Ghana, for instance, there is an issue of capacity there. A minor cannot open an account. A minor can operate an account through somebody who acts as a trustee. They all come, they have termination. So it's a pure contract. So all the elements of contract comes in, where a breach of a duty or obligation by either party can lead to a termination of the contract. And damages can be, granted or to any party who feels that his rights have been injured.
Yes.
So all those things are run in the relationship. And the basic nature of that relationship is a debtor-creditor relationship. In that, where the customer brings money to the bank becomes a debtor, because the bank takes the customer's money and has the free will to use the money for its business and pay back when the customer demands it. On the other hand, if in the relationship, the bank grants a facility to the customer, let's say a loan or overdraft, the bank becomes a creditor and the customer becomes a debtor. So basically, the relationship between the bank and the customer is one of a debtor-creditor. And either party can become a debtor here and a creditor there based on the type of transaction we have. Where it is a deposit, the bank is a debtor, the customer is a creditor. Where it is about loan, the bank becomes a creditor and the customer becomes a debtor. So it is important that that also is established.
So to also add, I think we need to also have in mind the fact that although we are looking at the element of a valid contract also, and my colleague rightfully painted to the issue of capacity, but there are also instances where a minor can also open an account. Okay, and we have issues of necessaries and all. So that's why when we were students, we were able to open an account because it was to receive our student loan. And so although we're minors and all that, we're able to open an account.
So there's a special dispensation.
A special dispensation where a bank will consider that although you're a minor, it still has to give you that dispensation in opening the account. And the other issue also of debtor-creditor relationship, the whole banking business thrives on trust and confidence. And so we are looking at instances where, as my colleague rightly pointed out, where a bank becomes a debtor when it receives money from the customer or the depositor. Now, unlike the other way around, where when a bank gives a loan or advances money to the customer, the bank ordinarily will receive a collateral or security to secure this. In the case where a customer gives money to the bank, the customer does not ask for the bank to give him. Yes, because, I mean, the trust is there. I have the trust that if I'm giving the money to EcoBank, if I'm giving the money to Zenith Bank, when it is time and I make a demand on the money, I'll be paid. So that's where the confidence...
Because of the security in the regulator's presence, because that is what the regulator does. Where when you want to operate a bank, you are required to meet some requirements, which includes some amount of money as the main, your start, startup capital. So based on that, it's like you have enough, so let's give you more.
Well, yes. So it's true that the regulator's duty is to ensure that trust that my brother was talking about. You know, the regulator's main duty is to protect the customer and to ensure that there is a sound financial system in place, because there is no bank in the world that can stand what we call a run. That is where all its customers go at once that they want their monies back. No bank. And the contribution of the shareholders to a bank, what you refer to as the money they have to deposit, will be about just 1/50th or 100th of the entire
Amount.
deposit base of the bank. A chunk of the amount that banks hold and use for their business is from depositors. For instance, in Ghana, the law requires that for a bank to be licensed or established, the bank must have a minimum of 400 million Ghana cedis. 400 million. And if you look at the balance sheets of most banks now, their deposit base is in billions. Billions. Some 10 billion, some 11 billion, some 5 billion. So you could see that the regulatory required capital is very small as compared to the total book, the loan, the deposit, base of the bank. So the regulator then comes in that, okay, if a bank is giving out a loan, as my brother said, they will take a collateral just to make sure that if in the event you don't pay, it's a fallback for them to go and get their money. However, the customer brings the deposit and there's no collateral. So the Bank of Ghana comes in to ensure that there is soundness in the system such that customers can come for their money at any time and get it. And there is also an arrangement which is called the cash reserve ratio, or some people call it primary reserve ratio. So what it means is that every deposit, the total amount of deposits that a bank gets from its depositors, the bank is supposed to send about, now there are several levels, about 25, up to 25%, that's the maximum. Up to 25% should be kept at the Bank of Ghana. It depends, there are certain criteria they use, but it ranges between 15% to 25%. Banks to keep that amount. So your deposits that you give to the banks, about 25% of them, maximum, should be kept to the Bank of Ghana. The bank doesn't use it for their business. They don't get anything of it. It is
just a fallback. So that's the customer's collateral.
That's it. The bank is also, Bank of Ghana is keeping that. And so, as he said, it's a matter of trust. That is why when it comes to the duties of a bank, you see that we emphasize a lot on the fiduciary duty, the duty of care. We emphasize on that one a lot. And so the Bank of Ghana is there to ensure that the customer is protected. So everything that the Bank of Ghana does is to protect the customer and not the shareholder. It is the customer and not the shareholder.
We know the bank is a business regardless, especially where it's a commercial bank. In fact, every bank operates for profits. Let's now look at what the obligations of the banker therefore are to customers. Who are your principals at this point? Because without the customer, you don't operate as a bank. Yes.
Okay, so thank you very much, and this is a very critical question. If you look at the relationship, my brother has emphasized a contractual relationship, and we have also spoken about how the business thrives on trust and confidence. Now, the first obligation that the bank must always observe is to be able to obey the lawful instruction of the customer.
Okay.
Yeah, so when I talk about lawful instructions of the customer, it has other sub-issues that we can look at. The first one is when the customer draws a check to be honored. Now, when the customer draws a check or presents a check, either by himself or through a third party and all, and certain criteria is met, it is imperative upon you, the bank, to honor that obligation. Once the check is presented, it is regular on the face, and then the amount indicated is up to the sum that is in the account. And then there's no suspicion of forgery or anything of that sort. The bank has an obligation to go ahead and honor that check. Okay. And so, I mean, it is critical. I mean, just about last month, a decision of the court came out where a bank in Ghana had to pay damages in excess of 900,000 Ghana cedis, and also had to pay interest on the sum, which was a dollar sum, in the account, because he failed to honor the instruction on demand. Okay, and it is because we want to instill confidence in the system. That's why the regulator, as well as the courts, will always make sure that you honor your obligation once a check is lawfully presented to you.
Yes, and to add to that, when it comes to checks, it's in two parts. As my brother mentioned, banks acting on checks in two capacities at every point in time. The bank can be acting as a paying bank or a collecting bank.
Yes.
When we talk about a paying bank is, for instance, let's say you bank with, let's say, Zenith Bank, and then you issue a Zenith check to someone. Zenith Bank becomes the paying bank because they hold your money, and they have to pay the customer. So it's a paying bank. But assuming you have an account with EcoBank, and then you receive a check from a customer, let's say a Zenith Bank check from a customer, and then you take the check to your bank, EcoBank, to pay into your account. EcoBank becomes a collecting bank. And the duties of a bank in those two instances are different. So for a paying bank, that is what he has rightly said. Once the instruction, the mandate is met, you have to pay. Because the traditional definition of a check is a negotiable instrument payable on demand. It's an instrument that, one, it is drawn, and all the necessary mandates have been met. You have to pay it on demand. So when it's a paying bank, you have to pay, assuming everything on it is correct. But when it is a collecting bank, you are also mandated to ensure that you collect the check for your customer and you pay into your customer's account. Because there are instances where a bank collects a check for a customer and ends up paying into another customer's account. So you have a duty to ensure that the check is credited
to the right
account.
So that dovetails into the requirement of diligence, reasonable skill and care on the part of the banker,
yes,
in handling the customer's money or assets.
Yeah.
And it's further connects to your fiduciary role.
That is it. So, I mean, the issue of due and care runs through the relationship.
Yes.
Because as a bank, you are dealing with money. And so you don't have to cause your customer a loss by acting negligently. And these acts of negligence have a lot of implications for both the bank and the customer's business. And so what it means is that before you even dishonor a check, assuming a bank receives a check, as I said, a collecting bank, and then you make a mistake and you pay into another customer's bank, and then your customer issues a check to another person to pay, with the hope that that check he received is going to clear by, let's say, 9 a.m. today. So he has issued a check on that account that, oh, somebody should have come and withdraw money from our account by 10 a.m.
Yeah.
Let's assume you pay the money into a wrong person's account. And then the customer's check and he said, oh, your account is not funded to be able to. You could imagine the legal issues there.
Yes.
Yeah.
So you have to exercise due care. One, ensuring that you don't, by your act or omissions, facilitate fraud on the account. That's the first thing you should do. There should be no fraud on the account. And also comes with a fiduciary duty to treat the account as if it was your own as a bank. So those duties are very important to ensure that the confidence that the customers have in the banking system is not eroded. Because once it is eroded, there will be no bank. Customers will come for their money. And only God knows where they will go and keep their monies. So it is important that we exercise the due care and that fiduciary obligation. And then there is another duty, which is to send statement of account to the customer at periodic intervals as agreed. So for instance, if you're a bank that you have agreed with your customer to be sending statement monthly, you have to abide by it and send the statement. Because it is when you send the statement that you also get to know the health or status of the account.
Great.
So that is also very, very important.
Okay, before we continue further, we'll go for a quick break. When we return, we pick it up from the issue of communication between the bank and the customer. This is Law Express. Don't go away.
Main duty of a bank, and that's the duty of secrecy,
privacy,
or
Privacy,
confidentiality on the account.
Yeah.
It is very major duty of the bank that there have been a lot of judicial pronouncements on it. You see, As a bank, you get a privilege to get a lot of data or information or personal data on your customer. So banks are now known as data processors. So the Data Protection Act, for instance, have put a lot of obligation on banks, even in the agreements they enter into, where a third party, they have entered into a contract, will have access to the information or data on their customers. There are certain clauses that must be put in it to ensure that those data or information are not abused. It is so important that there are only about 4 exceptions to the rule. And it is very important that the Bank of Ghana itself had stated, if you look at the laws governing banking, the Banking Act, it stated that that obligation is valid during and after the account. So even if the account has been closed, you cannot disclose it.
I think it only comes second to doctor-patient confidentiality.
That is it.
And it's up there with
That
it,
is it.
you know.
And as staff of the bank, you could see that that obligation is also valid during and after your employment with the bank. So you cannot say that I'm no more with the bank, so I'm going to disclose information. And that is important because it's a very critical aspect of the banking business. There are times you will see that former classmates can call you. Oh, I'm dealing with this person. And the person says, oh, the person has issued some check to me. I want to know if he really has money in his account before I go. It is very dangerous. Yeah. And sometimes the questions can come in such a way that you may think it's innocuous, it's harmless. And then you also go and disclose any information on the account. That is serious. If the customer gets to know about it, they can sue the bank for it. And banks take that very seriously. So as I mentioned, there are 4 exceptions to that rule. The first rule is that the bank can release information on the customer if a court order says so. So let's assume the police go to the court that they are investigating a certain suspected crime. And so they will need the account opening pack or the bank details of a customer to aid them. The courts will normally grant an order for that to be done. The bank is under compulsion to do that. The second one is where the customer himself has consented in writing or by implication. For instance, if a customer is applying to the embassy and has shared a bank statement with the embassy, and the embassy writes to the bank to confirm, the bank, by implication, is supposed to do that because the customer itself has issued it.
This is where I think there's a small gap. You have given the bank statement to the embassy, but you haven't told the bank to confirm. So I think that until you expressly tell the bank that I'm presenting this to the embassy and you are allowed to confirm, the mere fact that the embassy is holding the bank statement does not give them authorization to deal with my account.
I get you. There are forms they fill. It is
exactly.
We
So
have,
there should
we
be
have a process around it.
Yes, there should be a sign-off which says that when they come back, because for all you know, I just want to give them a bank statement, but I don't want them to deal with my. You know, the bank statements move from one date to the other. It's not like the entire history of your bank transactions. So there are limitations to
but
this.
I think normally when the embassies come, they don't ask for the entire transactions on the account. They confirm what has been brought to them.
That is my point. But then, even in that confirmation, there should be an express consent directed to the bank that when the embassy shows up, confirm my bank statement for me.
So what I would say to that is, in practice, there's always that collaboration between the bank and the customer, because there's even been instances where forged statements are presented. So at every point in time, a bank would want to call to confirm every information relating to the account that is presented.
Especially where people present other people's bank statements in support of their visa applications.
Yes.
So your point is valid. So maybe as practicing lawyers in banks, that must be an area that they must look at.
So this is like free advice from me.
So I mean, it is very critical also in the sense that there are instances where some unscrupulous members of staff will give out these statements.
People's statements?
Sale.
Oh.
people's statements, sell it to third parties without the customer knowing.
So this is where those checks
Yes.
come
This is
in.
where the bank
Yes,
gets
to
so
help.
it is very important as a bank, no matter what, whether it is consistent with what you have or however it is, you must
Communicate back.
communicate, confirm, because that reduces your liability.
Yeah. So I was talking about the exceptions. So
Yes.
the second is consent. The third one is where it is in a bank's interest. So assuming the customer has sued the bank, and for the bank to be able to defend itself, it has to provide information on the account to show that the fact being presented by the customer is not as it is. The bank can disclose it to the bank. And also there is another one where the bank is under a public duty to disclose. For instance, if there is let's say a criminal syndicate, and it has been brought to the bank's attention by the security agencies, the bank is under an obligation to disclose that this is this and that is what is happening here. So those are the 4 exceptions. Aside these exceptions, you have no right to disclose any information on the customer's account to a third party.
Even if it is the person's spouse
Never.
or child.
Never.
Yeah,
There have been
never.
instances. There is one case in banking law, where the man made a call to his relationship person, let's say a relationship person, and the wife was with him. So he was asking about the status of his account. There was something he was discussing on his account. And then whilst he was talking to the relationship manager, he said, "Oh, even my wife is here. You can even talk to my wife and tell you whether what I'm saying is not true." And then while they were talking, the guy went on to say other things on the account to the wife. The wife used that to elicit for other information. And then the man became angry and sued the bank. The only thing that saved the bank was that the man himself consented and gave the phone to the wife.
Yeah.
So under no account, and that is the most dangerous. Sometimes the spouse will come to you. "Oh, my husband is this. He is sick. I need money for him. So how much does he have in the account?" Never.
Yeah.
And also, even if the customer is dead, okay, when the account holder is dead, nobody can deal with the account until the person comes with letters of administration or probate. That is until the court authorizes somebody to deal with the account.
To deal with the account.
Very well. We sampled people's opinion on the streets
Very
regarding this topic. Let's take a listen to see if they appreciate the context of this conversation.
Very well.
The obligations of the bank to the customer, for what I know is, I know the bank work for us, the customers, and without us, the bank doesn't open. So I feel the bank should be able to keep our money secured and be able to talk to customers so they understand. Like in terms where a customer wants to take a loan or sign in a check or withdraw a check, they should prep the customer so he understands very well into detail, because some banks don't really, they feel like you should know because they actually know, and they feel the customers automatically they should know. So I feel the bank should be able to prep the customers very well into detail so they understand how the banking system works.
One of the obligations for a bank to their customers is confidentiality. Information of customers are not supposed to be shared. It has to be confidential to the bank alone, not outsiders. Example, like their account details, the money in their account. They don't have to share it to other people or even in the bank itself as well.
One of the obligations of banks to their customers is, offering of funds or providing access to their funds. And that is important because as a bank, I expect that, anytime I'm ready to withdraw funds or access my money, I should be able to do that.
Some of the obligations of a bank is number 1 for safekeeping, that's confidentiality, and number 2 to increase our savings in the accounts, let the interest rates go high. Number 3 for easy access. Yeah, so if I do any transaction, I should be able to flow. I shouldn't have any complications with the transaction. And number 4, to share my transaction details with me.
Some interesting views out there, and I think all that they said more or less fall into almost what we've discussed so far. I think the issue of confidentiality was emphasized there. It was mentioned there, and I think, as we've already mentioned, I think we've dealt with that subject, that on no account should a bank disclose information on the customer's account to a third party without justification. And the justification is where it falls within the exceptions that we mentioned. Yeah. So it's very, very important. I think another person also mentioned that the bank should prep its customers on loans and accounts. Yes, it's important. You know, one thing that I have seen most bank customers don't pay particular attention to is the terms and conditions. You know, when you're opening an account, they give you either a leaflet or behind the booklet, you have terms and conditions. I can say for a fact that about 99% of customers of banks don't read. They don't read that. And I'm sure it's because they know there is trust in the system. They can get their money when they go for it. Unless
well, it's because sometimes they must open that account with that particular bank.
Yeah.
Maybe you're about to apply for a facility, everything is working out, and you need to have an account with the bank to hold it. So
yeah, but the point I'm making is that if customers take time to read them, if you can open your account, have your minimum balance in there, sit down at the comfort of your home and read it and understand what it, because there are lots of things.
Is that not something you sign and return to the bank?
No, you know, what happens is that sometimes when you go to the website, you know, these are regulatory issues. So per regulation, the bank must make that information available to the customers. So the expectation is that you read it before you open an account. But in the event that you are not able to, the banks have their websites, and there is a link that you can use to access the information that you need to be informed on the terms governing the relationship that you have.
Shouldn't the bank be concerned at the point of opening the account whether or not you have read and understood these terms?
Okay, so what I also...
I know probably there's this clause that you should take against, that indeed you have. But you know how these accounts are usually opened. First of all, the banker who is pursuing you and breathing down your neck to open this account has targets to meet. Mostly it's somebody you know who just says, look, help me meet my targets. So they literally force this thing on you, and in a manner that you feel like you're actually doing somebody a favor. Yeah, you also need the account in some instances. Is it not these reasons that make it harder for people to actually take their time to read?
Okay, so I would also say that when it comes to these documents, there are instances where they are a bit bulky for the ordinary Ghanaian, even the literate ones.
Very fine prints, like small font sizes.
Because most banks makes a lot of effort to get it more concise. So that's how the font at times, I mean, in order not to get the customer overwhelmed. So ordinarily, even the literate might not be so much interested in having to read all these terms and conditions, but it's within your right.
Yeah, I'm sure if we were to vote, 90% of people have never really taken time to read
that. To read, yes. So it's within your right to want to maybe take it home, have some time to read through, and there are times when, depending on the sophistication of the account and all that, you may even have to employ the services of a lawyer. It's important. You may have to employ the services of a lawyer who can go to the terms and conditions, explain to you in detail for you to understand.
Yeah, the implications.
Because that is a foundation of the relationship. And also for a bank, it is always also important that for a bank, you insist that the person reads and forms an independent judgment or understanding of the terms and conditions. Because it's a relationship. And it's better you build that relationship on good faith basis, where the customer will not eventually come up and say, I didn't know this, and you people, and the normal mantra that, oh, the banks, they just kept this away from me with the intention of cheating me out of my money, and things of that sort.
Can we pick the conversation up to more personal requirements in terms of the obligations owed by the banker to the client, to the customer? I always like to come back to the issue of honesty in communication, promptness in bringing customer feedback, Okay, in terms of the customer has called you with an inquiry, you need to come back timeously to that person, because a few hours can be like a great difference. It can make a great difference in terms of some transactions, like forex transactions. If I know that there are some bankers who probably know that, look, in the next few minutes the rates will change, they'll go higher. So instead of coming back for the person to finalize their purchase, they wait for 2 hours, come back to say, oh, the rates have since changed, and so you're now buying at this rate. I totally get that, and I think that is also wrong.
That is an offense.
And for a bank, it is rare.
Yeah.
It is rare that the bank will deliberately, because for any bank, you believe in going to the full length with a customer, and most of these customers, they do a lot of the adverts for the banks, referrals here and there, because the bank services are good. So you wouldn't want to jeopardize our relationship by deliberately delaying a customer's transaction because you think the rates will favor the bank.
Let's come back to the issue of courtesy. I mean, Ghanaians believe that some banks have not been nice, or are usually not nice to their customers because of long-term existence and monopoly over some segments of the population, and probably because they're everywhere. I've had an encounter with a bank where I walked in as a customer, asked to have a counter check because I was not in a position to present my regular checkbook. And you know, counter checks do not come for free. They are paid for. The customer care person who was to handle me didn't see any justification in me asking for a counter check that I was going to pay for with my own money. She was very rude. She told me to get back to my house and wherever I lived to get it. And I, knowing my rights, just walked back to the next customer care person to ask her, please, how do I close my account? I want all my money so that, I mean, I wouldn't have to, you know, now get a counter check. I can just put it under my bed, right? It took the intervention of the branch manager to calm down things. Now, my situation is not isolated. This situation is not about just me. I know there are many people who encounter different aspects of some rude behavior from bankers to customers. What do you usually do in situations like this, apart from offering a coffee, taking the customer into the coolest, poshest part to talk to them? What else?
Okay. You see, when you come to banks, I kept on mentioning that banking is now about relationship, managing the relationship, customer service, excellent customer service. Because the product you are offering, almost every other bank is offering it. So what can you provide to the customer so that the customer will stick to you? And as a result of that, banks don't take customer complaints lightly at all. Even BOG, Bank of Ghana, to the extent that now Bank of Ghana takes reports on customer complaints. Bank of Ghana. Banks are supposed to file that report to them. When you go to banks, I mean, for banks I have had working stints with, customer service is a serious offense in the disciplinary code, to the extent that if a staff is found culpable for exhibiting gross disrespect to a customer or gross negligence in undertaking a customer's instruction, it is an offense that is punishable through dismissal. Because the only difference that banks can create in their service rendering now is how you provide service to the customer. So you can see that most banks will tell you the customer is king. And they say that because it is not that the customer cannot be wrong. They know the customer can be wrong. But they are training their staff in such a way that even if the customer is wrong, there is a way to handle the customer. You know, banks work with human beings, and in every human institution, once a while there could be lapses, and the banks know that. That is why they make it very costly for you to do those things. If you commit such, you know, a wrong, and it comes to the attention of management, they will treat it with a serious, you know, disciplinary measure that it deserves. So I know banks have that system in place. They don't joke with customer service. Like what you just said, person spoke to you rudely and that. When there's, and even the counter check, the bank makes money from it.
That's the point.
Yeah.
If we issue with a counter check, the bank will get some money from the counter check. So, as I said, they are human beings. We know that at times, some of the staff go beyond a certain threshold. The bank knows. So, there are measures to put them in place. And I can tell you there are measures that they use to put them in place.
And normally these people are taking up the schedule. They would proactively assign a more
back office
person who can, manage your account better for you.
Okay.
And it is also very important that customers out there always try to voice out their feeling. Because if it had been someone, your situation, the person would have just walked away, felt intimidated.
Yeah.
But if you always stand for your rights, because as we've said, if you are not there, the bank is not there.
Yeah, but
that's why we place emphasis on customers.
As a
being
client, you should not even be put in a position where you now have to fight actively
yes,
for your rights.
that shouldn't happen.
You are there to help me manage my assets.
That's not to happen, but because it's a human institution,
Very well.
some of these things tend to happen.
There's the advantage, or the comfort in the fact that misconduct does not go unpunished.
Yeah.
If somebody suffers heavily for that, they have the courts as an option.
Yeah.
They can go for damages
Yeah.
for your wrongful conduct as a bank,
Yeah.
and that becomes for you and your management to take up. We have some questions on social media. Let's
Very well.
handle those.
My name is Kwame from Accra, and I recently encountered an issue at my bank where my personal information was shared without my consent. In light of this, I'm curious about the legal obligations banks have towards protecting customer confidentiality. Can you also discuss how customers like me can seek legal recourse if banks violate our privacy rights?
We discussed earlier how important this aspect of the obligation of the banker is, to the extent that even in the Banking Act, the chief executive of a bank is supposed to swear an oath of confidentiality, as well as every employee of the bank. And the form is even attached as a schedule to the act. So that's how serious that is taken. So for anybody, you don't have any such rights to disclose such information, unless, of course, under those exceptions which my brother has mentioned. And then there has been other extensions. If you look at the new Banking Act, other extensions or exceptions to that particular when information can be disclosed without the customer's consent. So for the person whose information was shared without his consent, he has every right to take legal action against the bank for the due
They should just find a lawyer at that point.
Yes, for the due compensation to
would.
be paid in. But I will always suggest that for this, I don't know, and it is not clear from his question whether he has had an earlier engagement with the bank, because normally the process is to escalate. Maybe you may write to the bank complaining as to what happened, and then due to that, the interaction that will go on, then you can then take it from there, whether to go to court or whether you can reach some amicable settlement with the bank.
Like I said, find a lawyer.
No, yes, I mean, yes, you have a right to find a lawyer, but you see, when these things
it's
happen,
a relationship.
It's a relationship, so
Yeah.
it's always important.
That's what bankers always say.
It's always important you
Yeah.
report to the bank first, and then we try to resolve the matter with you amicably. Yeah, always do.
You
But the banks take that aspect seriously, of secrecy, very, very seriously. I don't like to.
I mean, but when when the bank is resolving this matter with them, you use your bank lawyers, right?
Exactly.
So why shouldn't the client, as a first recourse, get his lawyer so that he can also, or she can have a proper context as to what his rights are, even in trying to amicably fix the situation? Because the bank comes with their full professionals, and then there's this client who is already down because, you know, his or her privacy has been breached. Then you say, oh, come to us, let's try to resolve. If it fails, then you can escalate it by getting a lawyer.
Well, what
By all means, also arm yourself with a lawyer.
Normally, they get their lawyers to write to the bank first, and then we engage. Normally, they get their lawyers to write to the bank. That's what I know they do.
Yeah, but it's just because you said, oh, it's a relationship.
Yes, in resolving it, now we have moved, if you look at the trend of legal practice, it is moving from pure litigation to dispute resolution. And in dispute resolution, that's where you try to avoid the courts.
Litigation is one of the ways of dispute
resolution.
That's it. So let's not cross it out.
It's one. Initially,
those
you only say pure litigation, but when we talk about dispute resolution, it opens the avenues. You have ADR, you have mediation, etc. So that's why we always want customers to engage the bank first before they go to court.
Good evening, Noella and your team. I'm Owusu from Kumasi. I've encountered several instances where banks have charged excessive fees or hidden charges to their customers, a practice that undermines our trust in them. I'm interested in understanding the legal guidelines regarding the fees banks can charge their customers and how customers like myself can ensure transparency and fairness in banking transactions.
We have emphasized the issue of relationship and all. And so it is very important that for a bank, you communicate your fee to the customer. Fees come in various ways when it has to do with loans, when it has to do with other services that are provided. Okay, to the extent that, when you look into the Borrowers and Lenders Act, there's a critical requirement, mandatory requirement for every bank that you disclose the fee and everything in detail to the customer even before they execute the loan agreement. The pre-agreement disclosure. And it's a mandate that if you don't do, it comes with sanctions from the regulator. Apart from that, also the customer can take action for a recovery of the fees you have unlawfully charged, and also for you to compensate the customer as well. So for every bank, what the practice has been is to let the customer be aware. That's why you have to communicate. Let the customer be aware. These are my fees. Okay, for these services, these are the fees. For this, these are the fees. Okay, especially even for loan. Okay, the pre-agreement disclosure requires that for even penal charges, it should be disclosed. So the customer will not be surprised. Maybe along the line that you say, oh, because you defaulted, there's a penal charge of 34% per annum. Okay. Meanwhile, if maybe you had brought it up earlier, the customer would have said, no, this is too excessive, I can't. So the customer might be in the middle. So you need to
communicate first.
Communicate first.
Clearly.
Clearly. So for a customer who did not have this communication, and then he sees that he is being charged fees and all that, then clearly he has every right to seek for the appropriate redress.
It's now a regulatory requirement that banks must publish their fees at the various branches. You must hang them there so that when the customers enter the bank, they will see how much they will pay.
So this is just like akin to like a shop with price tags on all the
products.
Yes. So when the regulator comes to do their inspection on site, and you don't have that thing, you'll be punished as a bank. And even when it comes to loans, when you talk of excessiveness, the Bank of Ghana comes up with what we call the Ghana reference rate, which is the minimum amount a bank is expected to charge on facilities they grant. So what the banks add is something they call their margin, the risk margin. That's what they add to it. So that one is more transparent now because you know that if this month BOG comes up with this rate as their GRR, they call it GRR, then the bank, if the bank should add 5%, should get to this level to us. So the regulator have seen through this. So they have come out with guidelines on fees and charges. There are certain fees that they've told banks not to charge again. So banks have stopped. And even those days, some banks were not paying interest on savings accounts. The regulator came in to enforce that, and now banks are doing it. So as I said from the beginning, the regulator is there for the customers. So it is not a case that the banks have a field day, they are doing whatever they want. Even if a customer is not able to raise the issue, the regulator is always on the neck of the banks. Because, as I said, they also receive complaints from the public. And once they receive the complaints, they make sure they enforce they bring up certain regulations to ensure that the banks
ensure
are
the bank.
put in line and do the right thing.
We are at the tail end of our conversation, but before we wrap up, I would like to talk about the termination of the banker-customer relationship.
Very
How
well.
those come up briefly.
Okay, so on that, I mean, we've emphasized that it's a contract. And for every contract, there's a right for parties to either remain in the relationship or not. Even marriages fail. Yeah, so the requirements are clear. If you have to terminate the relationship, there's a notice requirement to give notice to the other party. This requirement for notice, I mean, on the part of the bank, at times the effect is minimal when that notice is not met.
Yeah.
But for a customer, it becomes a big deal
Yes.
because the person may need some arrangement to be able to organize his or her business
Yeah.
or the business to thrive. So it shouldn't come as a surprise that you wake up
So
one
they should be
day,
given ample notice.
ample notice that the bank is no longer interested in keeping
your
any
account.
relationship with you.
Does
And
it
so,
happen often?
It depends. It depends on
Because
how
what
the
would be the
transaction.
reasons for this kind of situation?
Well, if there is fraud on the account,
Yes.
if the bank sees that this account, they suspect it is not being used for legal purposes, they can. And aside that, even the current AML guidelines expects that the bank takes certain steps when they are not so sure about the source of funds for a certain account.
Yes.
You report to the FIC
Yeah.
for them to investigate. And then at a point in time, you have the right to terminate the relationship if you think it's not being used for the right purpose. So just
Could
as
it also be as a result of maybe some conduct of the
yeah,
the directors of maybe if it's corporate accounts?
yes,
Yeah,
yes.
so
I mean,
that-
it could be a basis. You see, it's a contract. So just as the customer can close his or her account at any point in time, the bank should also be able to do that.
To do that,
once the
yeah.
notice period is met.
Mhm.
Just that banks will ordinarily not just close your account.
Yeah.
They will close it for a reason.
A reason.
That's
And the reason mostly is because of fraud, or two, if you've exhibited some conduct that the bank thinks is not healthy for the relationship,
Yeah.
Yeah.
they will terminate.
So, with banks, they are supposed to clearly and expressly tell you why the account is being closed. Is that a requirement? Or they can just say, we no longer want to maintain this contractual relationship.
Okay, so I think that the legal requirement is a notice,
Okay.
not to go on giving
The
reasons.
explanation.
explaining, yes.
Because the customer has that option to just say, I don't want to work with you anymore.
Yes.
Shouldn't the bank have that
The
option
bank
as
should
well?
also have that option without going into explanations.
So once you fulfill the requirement of notice, which on the part of the bank is a bit higher
Yes.
by way of reasonable notice,
Yeah.
the client on the other hand can just do a same-day delivery, right?
Yeah,
I
as
want to
he
close
said,
my
yeah,
account,
because the banks
and
will
now-
normally.
Yeah, the impact on the bank
Not
is
feel it.
minimal. Yeah.
Okay. Finally, can we discuss the customer service agent and whether it's allowed for them to manage accounts of their spouses and close family members? I say this because of the requirement for privacy.
For me, I haven't seen any policy
Against that.
that. I haven't seen any policy. Just that a bank will not, if the bank knows, some of these things happen at the branch. So you don't know the relationship between this and that and that. The bank will not deliberately say that I have an account and it should be managed by your wife or my wife. They will not. But it could happen that coincidentally, as somebody comes to open an account in the bank and the spouse is aware, once the person is a staff of the bank and has signed the oath of confidentiality, even though he is your wife's husband, he is bound by that oath. He can see it. In that instance, it is not the case that the bank has disclosed to a third party. It is the case that a staff of the bank has that information. And when you look at the law, staff of bank are supposed to know the contents of their customer's account, like to a reasonable extent.
I would like to see how this plays out because I do not believe that anybody would want their spouse managing their accounts.
So that
in
is your decision.
In that close
So you
manner.
should not. So what it happens is that you should take a decision on how to handle it. you should take that decision will lie with the
So
customer.
the customer has to now call into the bank to say, look, you've assigned to me a customer service agent, but this person is a family member, so can you change him or her?
But the issue is that it is not only the customer service agents who can
Access
have
your
to the
account.
There are other people who can have
You
access
can
to
access
your
your
account.
account.
That's how it is.
I don't want to say
now
what's
you
on
use
my
your
mind.
discretion. You the person should
I
use your
don't want to
discretion
say
on
what's
what
on my
If
mind.
you don't
Let's
want your
see, the
spouse to
bank
know, then take a decision that will help you in that regard.
Great. It's been an interesting conversation, gentlemen. As always, my co-panelists today have been Michael Tepetina and Mr. George Ofori. My name is Noella Seidu. This has been Law Express, and I leave you with this statement that money in the bank is like toothpaste in a tube. Easy to take out, hard to put back in. And these are the words of Earl Wilson. Thank you for joining us once again. My name is Noella Seidu. This has been Law Express. Goodbye until next time.